Welcome everyone to yet another insightful live streaming program from the stable of immigrationquestion.com. We are thrilled to have you join us for an in-depth discussion on an important topic that almost all immigrants can relate to: transitioning from H-1B visa to a green card through the PERM process. I'm your host today. It's Maliha Fatima here, and I'll be your moderator to lead today's topic. My guest on today's edition is an astute Boston based immigration lawyer with years of experience in immigration law. With a broad range of experience in immigration law, she helps clients secure non immigrant status in the US to work and study. She ensures that her clients comply with the many restrictions placed on foreigners coming to the United States and changing immigration status while in the country. By providing proven strategies and anticipating obstacles, she ensures her client's process runs smoothly and efficiently. It's my pleasure to welcome attorney Monique with me here today.
Thank you so much for having me.
Thank you so much for joining us today. In spite of your busy schedule, attorney Monique, we look forward to have a great session with you.
Okay, great. Well, welcome everyone. I am going to try to give you the nuts and bolts of H-1Bs and PERMs in around 15 minutes, so bear with me. And I'll be more than happy to answer questions now and after, even after, if you'd like to email me. So basically, I'm going to be talking about the H-1B, which is the primary non-immigrant temporary working visa for professionals in the US. However, it's only a temporary visa, so you'll eventually want to transition to become a legal permanent resident or a green card holder. They call it a green card holder because the card is light green. And sometimes the people like to use the green card to serve for the PERM term. So the PERM labor certification application is the first stage of the green card process for most people. So I'll be talking about the interplay between the H-1B and PERM. Because the PERM green card process can take so long, especially if you were born in India or China, it's very important to maintain your H-1B status and also try to get indefinite extensions, because normally the H-1B is only good for 6 years. So I will be advising you on how to strategize and maintain a long-term H-1B status. So let's start with the H-1B Essentials. So it's filed by a US employer, and that could include the foreign national who owns more than 50% or has majority rights in the US entity. This is a new development. It's wonderful. Before self-petitioners couldn't file, but now if they own more than 50% or have majority rights, they can file on behalf of the entity. H-1Bs are also only for professional positions, meaning that the position requires specialized knowledge that normally you can only obtain through a bachelor's degree in a related field or a higher degree. And you must have that related degree. It could be from the US or a foreign academic equivalent. The H-1B is not universal work authorization, such as you get from the F-1 optional practical training. This is employer-specific, location-specific, job-specific. If something changes, a new petition may need to be filed. There's a prevailing wage requirement, which says that you have to be paid a certain wage, so they're trying to protect US workers. And because you're required to be paid a wage, there's no benching, which means that if there are periods of inactivity at your company, they must continue to pay you. Now, this is really important. The employer must pay the filing fees and usually the attorney's fees for this case. The only exception is if someone wants premium processing for an extra $2,805, then the foreign national can pay for that. It's not required all the time, and I'll discuss that later, but the employee is allowed to pay for those. Now, the H-1B is subject to a cap. There are only 60,000 numbers available if you have a bachelor's degree, and there's an additional 65,000, and there's an additional 20,000 numbers if you have a master's degree from a US institution. And every year, USCIS runs a lottery. It's in March, it's online, the company registers. If you are selected in the lottery, then the company files by June 30th of that same year. And if approved, The official start date is October 1st of that year. There are certain institutions that are not subject to that cap or lottery, and these are they called cap-exempt institutions. They're institutions of higher education, governmental research organizations, nonprofits related to institutions of higher education, and nonprofits that also conduct primarily research. So that's great. If you can find an employer that's cap exempt, you can start at any time. You don't go through the lottery. And by the way, this past year, the lottery, it was 20% of people won a number. So it's great if you can file at any time during the year. The disadvantage to getting your first job with an H-1B cap exempt institution is there's a kind of a lack of mobility, because then if you want to switch to an employer that is subject to the cap, you have to wait until they put you in the lottery, you're selected, and you win. So for example, if someone works for an academic institution and they want to switch over to a private pharmaceutical company, they can't just do a change of employer. They have to be entered in the lottery. So once you do obtain H-1B status, you can extend it, you can change employers, you can file amendments to it, and you're not subject to the lottery again for the most part. Only if you left the country for more than a year and you didn't want to recapture old time. But basically, when you change employers or extend, you're not subject to the lottery again. For extensions, you just have to make sure you file the extension before your current petition expires. And while that petition is pending, you get up to 240 days of extended work authorization. If you're changing employers, there's something called H-1B Portability, which allows you to port or start working with a new H-1B employer as soon as USCIS receives that new petition. Now, some of you might not want to take advantage of that because you don't know if that new petition will be approved and you don't want to give your notice and then the petition's denied. So then in that case, you might want to do premium processing to make sure that you have an approval. Also, what is relatively new is something called a 60-day grace period. So normally you can get up to 3 years at a time in H-1B status, but if you're terminated, you can get up to a 60-day grace period, or fewer than 60 days if the petition is expiring early than that period. Another kind of wonderful aspect of H-1B is it's a dual intent visa. It's a non-immigrant visa, but it allows you to have immigrant intent. So you can travel in and out of the country while that whole PERM green card process is pending. So now you get up to 6 years usually in H-1B status, 3 years initially and another 3, and it doesn't have to be 3. And all the time that you're outside the US, you can recapture, so it's not counted towards that 6-year cap. But you can get indefinite extensions beyond 6 years if you start the green card process early enough. And this, again, is really important because that PERM green card process can take many, many years if you're from India or China. So you will need more than 6 years. So one of the exceptions is where the employer files a PERM by the end of your 5th year in H-1B status. And I'll talk about the different stages below. In that case, you get 1-year increments. So you can file and get 1 year, then you can file again and get 1 year. You can also get 3-year increments if you get to the second stage where the I-140 is approved by the end of your 6th year. So those are the 2 ways that you can get indefinite extensions of H-1B status beyond 6 years. And you can even get H-1B extensions in some cases where your application to adjust status is pending, and I will talk about that later. So now let me switch back to the PERM legal permanent residency process, right, which is for your permanent status in the US. This is the predominant way to obtain legal permanent residency through employment. And there are 3 stages to this. There's the PERM stage labor certification where the employer has to get a prevailing wage determination, run recruitment, it files with the Department of Labor. And then if certified, it files with U.S. Citizenship and Immigration Services or USCIS, an immigrant petition showing ability to pay and that you have the credentials. And then the last stage is either they call it the I-45 application to adjust status to become a legal permanent resident, or if you can't adjust status in the U.S., to consular process abroad. So those are the 3 primary stages of the application for you to get legal permanent residency. So there are a few types of special immigrant visa petitions to avoid the PERM recruitment. There are the EB-1 cases. Some of them allow for self-petitioning, such as the EB-1A, extraordinary ability. And there's also actually an EB-2 national interest waiver, which allows you to self-petition. So an employer doesn't have to sponsor you or run recruitment. And there's also an EB-1B outstanding researcher petition for employers, but the employer must file for you. You have to show your outstanding researcher. And then there's an EB-1C national executive or manager petition as well, but the employer has to sponsor you. We're going to focus on the PERM. So first of all, it's important to realize that the PERM is a future job offer. You only have to hold that PERM position at the time the whole process is completed, which can take more than 10 years. And I'll talk about the exception where you can kind of port to a new job after it's been pending long enough. But generally speaking, it's a future job offer. You don't have to currently work for the employer, but in most cases you will be. Also, it has to be a U.S. employer and no self-employment is allowed. No ownership of the company is allowed. No 50% rule. This is because the PERM is to protect U.S. workers. The Department of Labor is saying you have to have a bona fide position that's open to any U.S. workers, and you have to run recruitment to make sure that none apply. They define a U.S. worker as someone who's a green card holder or a citizen or an asylee. It's not an F1 student. It's not an H-1B. So when we run recruitment, if any candidates who have an H-1B respond, they don't have to be considered at all. The PERM, similar to the H-1B, is employer specific and term specific, and which means that if you start a PERM case with an employer and then you want to switch employers, you have to restart a PERM case. The minimum requirements are absolutely required. The employer cannot use their preferences. They have to use the absolute minimum requirements. They cannot narrowly tailor the requirements to your background, because remember, this is supposed to be a job offer to a U.S. worker, and you are not at all allowed to be involved in the process of setting these requirements. The only thing the beneficiary is allowed to do is provide employment experience letters, educational documents to the attorney to make sure that they have met the requirements at the time the PERM is filed. The employer must also file a prevailing wage request, and they're based on 4 levels, based on where you're working, right, the geographic location, the type of job, the level of the job. And also, sometimes you can run the recruitment while the prevailing wage request is pending to save some time. The prevailing wage requests are taking about 6 to 7 months, and the recruitment can take as little as 2 to 3 months. And most employers might wait to get the prevailing wage determination before they start, because salary must be noted on some of the recruitment, and you don't want to have to redo the postings. Now, once you file the PERM, that's called your priority date or your place in line. And this is really important to remember for the 5th year, where you get the additional H-1B extension based on a PERM being filed by the end of your 5th year. So when you file the PERM, that is your priority date, your place in line for a visa number, which I'll explain below. Now, when you file, DOL has been certifying these cases within about 13 months. In my experience, very few are audited. If they're audited, it might add 4 to 6 months. And if they're audited, usually the Department of Labor is just asking for the recruitment documents, because when we file online, no documents are included. It's just the actual form saying that it was done, kind of like an IRS audit, right? You file your taxes and hopefully you're not audited. And if we go to the next stage, that's the I-140 Immigrant Visa petition. At this stage, the company has to show the ability to pay your wage, and you have to show that you had met all the requirements at the time the PERM was filed. And this ability to pay is not demonstrated from when the I-140 petition is filed, but it has to be demonstrated from when the PERM application is filed. And this is really important. So remember, the employer doesn't have to be paying you the PERM amount or employing you until the green card's approved. But it has to show it could have paid you that PERM salary when the PERM was filed. So some employers, if it's a little tight, they may say, well, the PERM required wage is $60,000 and the beneficiary is making 50. I'll keep him at 50. And then I'll pay him 60 when the green card's approved. Well, that's great, but the employer has to hope that they always had good years since the time they filed the PERM, because they have to show that they could have paid that $10,000 difference, which is usually demonstrated on the company's tax returns, audited financial statements, annual report. Sometimes immigration will accept secondary evidence, but that's an important note. Another really important thing is once you get that I-140 approved, that it allows you to get that extension of H-1B beyond 6 years unless you get a 3-year extension. So you either want the PERM filed by a certain date or that I-140 approved, remember, to get the H-1B extensions. So now we get to the 45 application to adjust status stage, where you actually apply for the green card. So what happens is when the PERM is certified, you go to file the I-140. And by the way, you can file the I-140 via premium processing, again, for an extra $2,805. And they usually can take about 3 weeks instead of many months. And also at that time, when the PERM is certified, you look to see if a visa number is available for you to file to adjust your status in the US or consular process abroad. So what is adjustment of status? It means you get to change your status from an immigrant, non-immigrant H-1B to an immigrant, to a green card holder. And you get to do it by remaining in the US. You don't have to go to a consulate and go to an interview. And when you apply to adjust your status in the US, in a sense, that puts you in status. While that's pending, you can remain in the US. You can get work authorization through the employment authorization document, the EAD. You can get travel permission called the advanced parole travel document. And families can follow to join you and get their green card with you. You must maintain your non-immigrant status at the time you file, or you have to show you've always maintained your non-immigrant status at the time you file your adjustments of status application, with one exception. If, since your last entry, you have not worked without authorization or otherwise violated the terms of your status for more than 180 days, then you can still adjust your status in the US despite that gap in your lawful status. Also, another thing is, again, if at the time the PERM is certified, you go to see, and you file the I-140, you go to see if a visa number is available. If it is, you can currently file simultaneously that 45 application to adjust status and the I-140. If a visa number is not available, then you wait. So this is how it works. Every year, 140,000 visa numbers are made available worldwide. And each country gets the same number of visas. And we know there are far more people from India and China applying. So what happens is it creates a really long line for people from India and China. And the Department of State, what they do is they have a cutoff date when a specific category gets oversubscribed. So not only do you have each country getting a certain number of visas, but you also have different visa categories. You can have the EB2 category, which is where master's degree or bachelor's and 5 years of experience is required, or you could be in the EB3 category where a bachelor's degree or 2 years of experience is required. And so they have different categories for the different countries, and they determine if a visa number is available. And the Department of State issues a visa bulletin, which shows that cutoff date, and applicants with a priority date, remember the date that your PERM was filed, if your priority date is earlier than the application date in that chart, then you can file to adjust your status, or you can, if you're consular processing, the National Visa Center will start that for you. So to determine whether it's available, USCIS also relies on this visa bulletin. And this visa bulletin is issued actually usually the middle of the month before the next month. And sometimes immigration will use the filing dates chart. And sometimes it will use the final action dates chart. So in the visa bulletin, there are two charts. One is called the final action dates chart, which says when your application can be approved. Another is the filing dates chart, which tells you when you can file the case, which might be sooner. But oftentimes, like for August, USCIS will only allow people to use the final action dates chart to file their case, and that is much more backlog, takes longer. Another important thing is that if after you file to adjust status, the visa number retrogresses, it goes backwards or it freezes, you can still maintain your adjustment of status application. You can still continue to get the employment authorization document, extensions of it, and the advanced parole. There's another interesting thing you can do once you have the adjustment of status filed. You can transfer an adjustment of status based on a second I-140 petition. So let's say an employer starts with an EB3 case, which takes longer, and then you have another employer file an EB2 case, or the same employer files an EB2 case, which is much faster. Then you can swap out the EB3 for the EB2 to be the basis of your adjustment of status case, so you could get the green card more quickly. They even allow for downgrades. Believe it or not, sometimes the EB3 lower category goes faster, especially for people from China sometimes, than the EB2, and I have downgraded cases. Another important thing after you file your adjustment of status is that you can abandon it if you depart before the advanced parole is issued, unless you have been maintaining your H-1B status. Because remember, when you file your adjustment of status and you get this employment authorization document, the EAD, you can actually work with that EAD and you don't have to renew your H-1B, but I highly advocate doing so because if you have to travel and you want to re-enter as an H-1B, it gives you more protections against removal. If you have to rely on an advanced parole document to travel outside the US, you have fewer rights as a parolee. So another kind of hardship is even if you're terminated while your 45 is pending, you could still actually maintain it. And this is where I'm going to talk about portability. So portability says that once your I-140 is approved and your adjustment of status has been pending for 180 days, that you can actually port or move to a new employer in a same or similar occupation. This new employer does not have to restart the process, doesn't have to file a new PERM application for you. They just file something called a Supplement J. And then when the 45 is approved, it's based on employment with the new employer. So you have to report to the new employer. You wouldn't report to the original employer. And it doesn't matter if the location is different, if the salary is different. And you can even use portability for different jobs within the same company. Because remember, the PERM case is employment specific in terms of the role and the requirements. So let's say you are promoted to a project manager from an engineer. You're supposed to get a new PERM for that. But if now you have an I-140 approved and your 45 has been pending 180 days, you can kind of port to the new job within the employer and they don't have to restart the process. The only exceptions to portability, again, is if the I-140 is withdrawn before the 180 days, or the I-140 is denied or revoked at any time except when it's revoked after, based on a withdrawal filed after 180 days. Basically, once your I-140 has also been kind of pending for 140 days, it's like you're kind of clear. So those are the basics about the green card case. And I just wanted to bring up one more thing, just so you're clear on the interplay of H-1B and green card status. Remember, if you have a 45 pending and your I-140 has been approved, if you're terminated, if your H-1B status is terminated, you have to scramble to find a new employer in the same or similar occupation to file the Supplement J. And this is important. The Supplement J should be approved before your green card is approved. Because if they approve the 45 when you haven't had that ability to port, then everything is basically, it's invalidated. So it's very important to get that Supplement J in before. Immigration isn't going to inform you of whether afterwards they do, but when you file it, they don't provide you with like detailed status. But if you just get it filed before your green card's approved, that will save you. Okay, so now, sure, I'd like to open it up to questions.
Absolutely. Thank you so much for in-depth introduction towards the PERM process. The journey of H-1B to green card can be really complex, but with right guidance, of course, it can be smoother. Right? So we have the first question, that is, for many H-1B holders, the PERM process is the most common path to obtaining a green card. Can you explain the PERM labor certification? And why is it crucial in the H1B to green card process?
So the H-1B is a temporary visa. The PERM is the first stage of the application for legal permanent residency. You can't just stay indefinitely on an H-1B. It's only good for 6 years, and then you get indefinite extensions if you've started the PERM process. So the PERM labor certification application is the first stage of the green card process through employment for most foreign nationals.
Thank you so much for the valuable insight. That was a great start for this process. Moving on to our next question: who is eligible and what are the basic requirements
For the PERM or the H-1B?
for the H1B?
An H-1B, it must be sponsored by a U.S. employer, or if the foreign national owns more than 50% of the company, that entity would sponsor it. They have to offer a professional position, meaning that it's recognized as requiring a bachelor's degree in a particular field. And they have to have a related degree. They have to be paid a required wage. They have to be treated as a W-2 employee. And they, if they're subject to the cap, they have to go through the lottery and be selected.
Right, that's quite interesting. That's quite insightful. Thank you so much for the insight, Attorney Monique. Moving on to our next question. We do understand that H1B is a dual intent visa, which allows you to pursue employment based permanent residency. Can you take us through the adjustment of status procedure?
So after you get the PERM certified, you go and see if a visa number is available to apply to adjust your status. If yes, then the company files the I-140 Immigrant Visa petition, and the foreign national files the adjustment of status application to be able to become a legal permanent resident in the U.S. without leaving. They could get work authorization and travel permission. If a visa number is not available, they wait until it does, and then they can file to adjust their status in the U.S. They will have to get an immigration-style medical exam. They'll have to show they're not subject to any bars of inadmissibility. They haven't committed any heinous crimes. They're otherwise approvable. And then they're not interviewing people anymore. So usually the approval will come in the mail, and they'll get an alien registration card.
Absolutely. Thank you so much. That was a great overview. Transitioning from an H1B to a green card can present a lot of challenges, right? But understanding these can help us navigate the process more smoothly. We have a lot of questions coming from the audience. I'd like to address each one of them. The first very question that we have is from Mr. Oluwa. What are the requirements needed for someone to meet up? I assume he's talking about H1B.
I'm sorry, you cut out on me. What are the requirements for an H-1B?
Yes, what are the requirements needed for someone to meet up?
I don't know what meetup means.
Right, right. I mean, it may be like, what are the requirements that are required to get an H1B? Like basic
Okay.
requirements.
Again, the H-1B is only for professional occupations. And so for example, like a data scientist, financial analyst, computer scientist, the foreign national, the beneficiary must have at least a bachelor's degree in a related field. The employer must be offering them an employment relationship, issuing them a W-2. They must be paying them the prevailing wage, the required wage for that particular location. And they usually have to show that they're being supervised and controlled by that employer.
Thank you so much for the valuable insight, Attorney Monique. Moving on to our next question. Are there other ways to get green card from H1B aside from PERM?
Yes, so you can do a self-petition through an EB1 extraordinary ability, showing you have sustained national or international claim at the top of your field. They're very challenging. You can try for an EB1B outstanding researcher petition to show that you're internationally recognized for your novel work, and that has to be sponsored by an employer. You can try an EB1C multinational petition, which is where you've worked abroad for 1 year within the past 3 years as a manager executive, and you've come to the US to work for an affiliated company, and the employer sponsors that. You can try an EB2 national interest waiver, where you can show you're well advanced to benefit the field. And it sounds pretty benign, but it's actually super challenging, the national interest waiver too. It's not a great help for people from India or China who already may have an EB-2 based on the PERM, because it's not going to move any faster. But if they want mobility, they don't want to be stranded with the same employer, they may want to file a national interest waiver anyway, which allows them to work for themselves or anyone if approved.
Thank you so much for breaking that down. That's quite interesting. Moving on to our very next question, can you go over the PERM process from recruiting process to the issuance of EAD for H-1B spouse? If you could also share how long on an average it takes for the EAD to be approved. Thank you.
Okay, first I should note that if an H-1B has an I-140 approved, but a visa number is not available to adjust status, the H-4 spouse can get employment authorization. So they don't need to adjust status. Their spouse just has to have an approved I-140. But if you're going through the PERM process, firstly, the employer runs recruitment, they're waiting for a prevailing wage. Once the prevailing wage is issued, if it's high enough, then they may have already started recruitment or they run recruitment. If no qualified U.S. workers respond, then they can prepare and file the PERM application online. If certified, then again, they file the I-140 Immigrant Visa petition to show that the beneficiary met all the credentials and all the requirements and that they have the ability to pay. And if at the time the PERM is certified, a visa number is available, they can simultaneously apply for the I-45 application to adjust status. And when they do that, they can apply for the EAD and the AP, and they were notoriously slow for a long time, but they've sped them up a little bit. I'm going to say maybe it's more like 3 to 6 months now, but it's constantly wavering. So don't hold me to it, but maybe 3 to 6 months. The advanced parole is just taking longer.
Absolutely, that's a lot to know. That's quite insightful. I mean, I think it's quite impossible to go about these processes without an attorney. So, if you'd like to give out your contact details to our audience who'd like to reach out to you for any process, please feel free to do so.
Sure, please visit my website. Just Google Monique Kornfeld with a K and send me an email through my contact page. Please do.
Thank you. Moving on to our next question. America with a question mark. This process needs too much money and we are a family. If you don't have money, is there any help as to pay when he or she has reached there? I think there refers to America, the United States itself.
There are fees. There are attorney's fees, there are filing fees, there are recruitment fees. I should let you know, the PERM, the first stage, must be paid by the employer. The employee cannot pay. The employer is prohibited from reimbursing the employer, and the employer must pay for all the recruitment fees. However, for the second and third stages, the employer or employee or both can pay for those fees.
Absolutely. I'd like to take a window for the audience who've just joined us now. This is immigrationquestion.com live streaming program. Immigrationquestion.com is a revolutionary platform that connects immigrants and users with qualified immigration attorneys. You can ask your questions for free and you'll be connected to a verified registered attorney on the platform. For immigration attorneys, this is your opportunity to scale your practice to the next level. Register as an attorney and get up to 10 free client leads upon sign up. Moving on to our next question. Hi everyone. So now I'm on a visitor's visa. What are my options to get a social security or a work permit?
Again, you can see if you're eligible for an H-1B visa, and if you are, you can find an employer to sponsor you and enter you in a lottery. The reason why we have 12 million undocumented people in this country is because there are not enough working visas. So if you're a professional and you don't get selected for the H-1B lottery, very few options. You could become an F1 student, and when you graduate, get optional practical training. If you're an extraordinary ability alien, you can get an O1 petition. If you're a manager, executive, or specialized knowledge person who's been working abroad for 1 year within the past 3 years for a company and you're coming to the US to work for an affiliated company, you can maybe get an L1 intra-company visa petition. There are J1s available. A lot of scholars use them to study and work in the US. I could go through the whole alphabet. What I would recommend someone do is contact an attorney to see what their background is and what the different visas are. But the primary working visas really are the H-1B, the O-1. There's also an E-2 treaty investor visa, which allows someone to invest significantly in the US if there's a treaty between their home country and the US. There's also an E-1 that involves a treaty trade visa with a substantial trade between your country and the US. There are a host of these little more obscure visas, and that should be done with a consultation with an immigration attorney. Oh, and there's finally something called it's new International Entrepreneur Rule, which allows certain entrepreneurs who have received a certain amount of investment from qualified investors to be able to get a type of parole document that allows them to work in the US. It's usually up to 2.5 years, and then they could extend it for 2.5 years. But there are a lot of really stringent requirements for that.
Absolutely, and I also see that you'd written a very insightful blog on your LinkedIn. I mean, if you have any audience, you can definitely check it out. I'm a huge fan of it. Moving on to our next question, I'm looking for how to get citizenship from my adopted son. I'm an American and Costa Rican. I adopted him in Costa Rica and we live in Costa Rica. He's almost 14 years old.
Okay, I don't do adoption cases anymore. Most people who want to help their adoptive children immigrate, they go through an adoption agency.
Totally. I mean, if we have someone from the audience, you might as well do that. Moving on to our next question, are there any recent changes to PERM process or requirements that I should be aware of?
Recent changes, nothing that would really affect the beneficiary. It's more for the immigration attorneys that have to deal with their portals, which are unnerving. They're constantly changing their different platforms to file things. I guess the one benefit to the new platform is that the beneficiary can kind of track their case, but it's not terribly helpful because all it says is, if it's pending or not. But it's like it's either pending or it's certified, and I could check that in 2 minutes. So it's not a very transparent process, unfortunately. But there have been no major changes to the PERM process. I think that the major change recently was the H-1B process. They used to deny cases if the beneficiary was the sole proprietor of the U.S. entity that sponsors them for the H-1B. They used to say it's basically like self-employment, it's not allowed. But now they're allowing it if you have a 50% ownership or majority interest.
Thank you so much for that insight. We have Steph thanking you for the very good information.
Thank you.
Moving on to our next question, when transitioning from H-1B to green card, the sector you work on drastically influences the process and requirements. Are there any specific sectors that have notable requirement or process that may lead us to a change?
No, the H-1B and PERM process are the same rules regardless of whether you're computer science, data scientist, financial analyst, marketing research analyst. You have to, for the H-1B, it has to be a professional position. You have to have the related degree. You have to be paid the prevailing wage. And for the PERM process, the employer has to sponsor you, has to get a prevailing wage determination, has to run recruitment. And the visa number availability from the Department of State, they don't break it down based on industry. So, there have been some information, or maybe they're going to make some changes for people in the STEM field that they've been talking about, like, I don't know, making more visa numbers available or something, but that hasn't happened yet.
Thank you so much for the insight again, Attorney Monique. Moving on to our next question. After requisite forms filing and processing, an interview with a USCIS officer to review an employee's green card application will have to be completed. What tips and tricks can you possibly offer to applicants for a successful interview session?
So if you're talking about people who cannot adjust their status in the US, because I do file PERM green card cases for people who have not been in the US and they will only come to the US upon approval of the whole case. And at their immigrant visa petition interview, they will be filing a DS-260 online. You should, since it's a very detailed form, you just have to be very honest about any visa refusals, all travels to the US. They're going to do extensive background check on you. And it's not going to be in your control, but sometimes they do administrative processing for people. And that's usually for people whose name is maybe similar to someone's name who's caused trouble for the US government. And it really is a Kafka-esque situation, because when your case goes to administrative processing, they don't tell you anything. They don't tell you the reason. And there was a recent Supreme Court case that held that they don't have to. That this was a marital-based case, but this U.S. citizen had filed for her spouse, and they denied his immigrant visa, and they wouldn't even tell them why, and they had to fight and fight and fight. They found out that because he had a tattoo that was similar to a drug cartel's tattoo, they thought he was a drug dealer. Well, it ends up it wasn't, so they have to refile. But the Supreme Court held that the Department of State was not required to provide the reason for the denial. So hopefully, you just get your medical exam, you complete the forms, you upload all your civil documents. It's really very straightforward. And at the interview, you just make sure that you say that you're coming to the US to work in the PERM position. So be familiar with the position that was filed for you. And sometimes you can get an updated letter, something from the employer saying that they reaffirm their intent to employ you upon entry into the US.
Absolutely. That also reminds me of one of your blog that you had posted in regards to Apple and Facebook on a pending lawsuit against SpaceX, where there is some kind of discrimination against US workers. Do you have something that you'd like to talk about it here?
I don't have any other information about that case. There is a rule in immigration, but it's more really an area for employment lawyers. We're not allowed to discriminate based on national origin. And so people can definitely sue employers if they feel they have been discriminated on that basis.
Oh, that's quite a power there. Okay, so I guess yes. So I guess on a final note, in light of recent policy change and programs, how do you think President Biden's recent immigration policies, including the Parole in Place program and the current H-1B visa regulations, impact the options and processes available for undocumented immigration and skilled foreign workers seeking legal residency in the United States?
So President Biden has this new order that would allow spouses of U.S. citizens who they either came here without inspection or they violated the terms of their status, but it's usually for people who came without inspection. It allows them to stay in the U.S. and get their green card. Normally, when people have been out of status for so long or they entered without inspection, they have to leave the country and then they can't come back for 10 years or maybe even more. So what he's doing is he's allowing certain spouses of U.S. citizens to remain in the U.S. and get their green card if they can show that they've been here 10 years. And I don't have all of the other details, but you haven't committed certain crimes, but they will allow that's a big sea change, because normally if you want to sponsor, let's say a spouse who entered the country without inspection, you have to get an extreme hardship waiver approved before they leave to get their green card outside the US, because they're not eligible to adjust their status in the US because they entered without inspection. And normally you have to get an extreme hardship waiver showing, again, exceptionally unusual hardship to the US citizen spouse if the person had to leave and be gone for so long. So what this does is it really makes it so much easier for those spouses who have been here 10 years. But it doesn't affect, this is an employment-based session. It doesn't affect employment-based or H-1B or PERM cases at all. That parole program is not going to touch this area at all.
Totally agree with that. Thank you so much for the valuable insight. I think that is all we have for you today, viewers. A huge thank you to you, our special guest, who honored our invitation. Thank you so much, Attorney Monique, for a pleasing and a knowledgeable session. We cannot wait to have you another time.
I look forward to it. Thank you very much. Okay, take care.
Take care. Thank you so much. This is immigration.com, a platform built to answer all your immigration queries. And for attorneys, we help you upscale your business effortlessly. Don't forget to explore all that immigration question has to offer you. Visit our website at www.immigrationquestion.com to sign up today and start getting your immigration questions answered. Are you an immigration attorney looking to grow your practice with zero cost obligation? Register now on immigrationquestion.com and have up to 10 free clients leads sent your way. Thank you so much all for joining today. See